Well, good afternoon, everyone. I'm Michael Cunningham. I'm the chairperson of the Community Housing Resource Board of Anderson, and we are here as co-sponsors of this fair housing workshop, and today we'll be focusing on landlord-tenant issues. As with our previous workshop, we are honored to have with us today Charlotte Osmer with South Carolina Legal Services. They have been an excellent partner with us in covering landlord, tenant, and fair housing issues, and we expect nothing except for more of that in the future. I would also like to take this opportunity to thank the City of Anderson first for sponsoring this location for our workshop, but also for years and years and years of steadfast support of the Community Housing Resource Board and fair housing issues. They have been also a great partner. And with that, I'm going to turn our workshop over to Charlotte Osmer with South Carolina Legal Services, and she's going to start her presentation, and then I think there'll be a brief pause, and then we'll get a chance to hear from Jordan Evans with Anderson Interfaith Ministries, who's going to be talking about a phenomenal program around rental assistance, and then he'll turn it back over to Charlotte, and we'll finish up with the rest of our fair housing workshop. And so with that, I'm going to turn it over to Charlotte and welcome her, and hope all of you enjoy the next hour or so of great information. Thank you.
Thanks so much, Michael. I really appreciate the opportunity to be here again. So today we're going to be talking about a few things. So the first thing I'm going to talk about briefly is just South Carolina Legal Services, who we are, what we do. Then I'm going to talk about the CDC moratorium, and then this is when Jordan's going to step in towards the end of this part of the presentation to talk about rental assistance and how to apply and what the eligibility criteria is. And then lastly, we're going to talk about landlord-tenant law, and I'm going to focus on the three main areas that we see mostly at legal services, and that's going to be evictions, repairs, and security deposits. So South Carolina Legal Services, we are a private, nonprofit, statewide law firm. We provide free legal assistance to low-income South Carolinians. You do have to apply for our services to see if you qualify, but if your case is accepted, we do not charge attorney's fees. We have 9 offices across the state. We serve all 46 counties of South Carolina. The Greenville office serves Greenville, Anderson, Oconee, and Pickens counties, and this is a picture of our office located in downtown Greenville. So we handle a wide variety of civil cases. So we handle consumer and finance cases. Let's say somebody's car is being repossessed or you're having issues with a title loan. We handle education cases if a student needs special education assistance or if that student is being recommended for suspension or expulsion. We can also help with that. Employment, we help with unemployment benefits. We can also help with wages that are owed to an employee, and in some cases, employee discrimination. We handle family. This is a large area for us. We can handle divorces based on domestic violence. We can also handle custody, visitation, adoptions, a wide arena in family cases. Housing is another large area for us. Obviously, we handle a lot of evictions. We also do public benefits, Social Security, Medicaid, SSI, as well as other elder law and tax issues. What we can't do is anything related to criminal. That's the main thing. You would have to go to the public defender's office. We are prohibited from handling anything criminally related. So to apply for our services, you can apply at our telephone intake line. That number is 888-346-5592. That is open Monday through Thursday, 9 a.m. to 6 p.m. Or you can go to our website at sclegal.org, and that is available 24 hours to submit your application. So we're going to talk about first the eviction moratoriums. We're going to talk about a little history, how we got to where we are now. So as everybody knows, when the pandemic hit in March 2020, one of the first things that the South Carolina Supreme Court did was issue an order that it blocked evictions statewide. That issue was ordered on March 18th, 2020, and that absolutely prohibited in public situations and private situations with private landlords, public landlords, all evictions were halted in the state of South Carolina. And then they were allowed to resume on May 15th, 2020. Around the same time, the Federal CARES Act was passed, and that in itself contained an eviction moratorium that restricted evictions based on the non-payment on rent for any subsidized housing properties. So if you were in public housing, you have a Section 8 voucher. If you live in a project-based subsidized housing unit, if you fail to pay rent, there was a prohibition for 120 days that those landlords could not file evictions against their tenants. Then came the CDC eviction moratorium. That was issued in September of 2020. So it was originally in effect from September 4th through December 31st, 2020. Then it was extended until January 31st, 2021, then again until March 31st, and now again until June 30th. So there was a couple of different forms that were issued throughout this period. So if you, let's say, you did your eviction moratorium declaration form in November 2020, you did not have to execute a new one because it was extended in January, March, and June. If you had executed one, that was sufficient. You did not have to continue executing a new form. So this eviction moratorium is only eligible for residential cases. It does not apply to commercial properties, but it only applies for non-payment of rent. It did not apply for other areas. So if you're being evicted for a lease termination or end of lease term, that could go forward. So this only applied, and it only applies to evictions based on non-payment of rent. So this eviction moratorium does not cancel or forgive any rent that's owed, and the tenant is still going to be legally responsible for paying rent. And if you see on my presentation, if you see an LL, that stands for landlord, and if you see a T, that stands for tenant. So step one, you have to determine whether you qualify for the CDC eviction protection. And so the CDC issued a new form, as you can see up on the screen. And so this is the most recent form. And so it has two columns, and that column is available to see if you qualify or not. So basically there's a couple of boxes that you can check, but if you're a single filer and you're earning less than $99,000 a year, you'd be eligible. If you were a joint filer and earning less than $198,000 a year, you would be eligible. They also added to this new form that if you received a stimulus check, then that was also income-based. So if you received that, you'd also be eligible. So first column is to determine if you're financially eligible for this program, and then the second one, in column B, it says that you had to determine if you're unable to pay rent because of a substantial loss of household income, you lost your job, you have a lot of medical bills. So even though it makes it seem that this is pandemic related, the reason that you lost household income did not have to be related to COVID. As long as you had a substantial loss of household income, then you qualify. So if you're able to check one box in column A and one box in column B, then you're eligible for the CDC eviction protection. So then you would turn to the second page, and then you would have to check these boxes to make sure that you are income qualified, that you're eligible, and that if you were to lose housing, if you were to be evicted at this time, you would either be homeless, you would be in a homeless shelter, or you'd have to live with others in tight quarters. And so the whole idea behind this eviction moratorium is to prevent the further spread of COVID by not having people cohabiting in close quarters. So it's really important to understand that once you're executing this document, you've got to make every effort you can to continue paying as much rent as you can. You also then have to apply for rental assistance. And that's what Jordan's going to talk about here shortly. And it's also important to understand that this document is being signed under penalty of perjury of law. So if you are not being truthful, it could be prosecuted criminally. So it's just important to be truthful when executing this document. So what happens after you, if you're eligible for this document and for the eviction protection, go ahead and complete it. And then it's also important to note that every adult tenant in the household has to sign their own declaration. So it can't just be the head of household. So I recently had a client who was an adult, and he lived in the housing with his brother and sister-in-law. All three had to complete this form. So after you complete the form, and every adult household resident has completed the form, make sure you keep a copy of it. If you don't have a way to make a copy, take a picture of it, and you have to present it some way to the landlord. You can do it in person, by mail, email, fax, but you have to make sure that the landlord knows about it. The tenant is not going to be protected from the eviction moratorium unless the tenant gives that landlord the declaration. So how about for people who the landlord has already filed an eviction. So you can go ahead, complete the form, and give it to the landlord, but after that, you got to let the court know that you have done that in order to stop the eviction from going forward. So we have an additional form available, and that should be available on the website later this evening or later this week. So we have this additional form that lets the court know. It has all the information about the case that you can fill in. It's just a way to let the court know that you have completed the tenant declaration and you have submitted it to the landlord, and therefore the eviction should be halted with the courts. All these forms, the tenant declaration form, we have it along with an instruction sheet on how to complete it, and then same with the notice to the court for the CDC declaration. We also have an instruction document, so it just lets you know how to complete it and how to turn it into the court. So it's just really important to remember that you might be eligible for the CDC moratorium on evictions, but you got to take action to get its protection. So you can't just be automatically think it's just going to stop just because you're eligible. You got to take proactive measures to make sure it actually prevents the eviction. So you have to make sure if you're eligible, that you complete the form. You have to give it to your landlord, and then you also have to give notice to the court. So if you need housing assistance, we would normally recommend calling 211. That has been the centralized number for anybody who needs rental assistance. But as Michael had mentioned earlier, we have Jordan here from AIM who's going to step up now and talk to you about how to get that rental assistance.
A little bit taller. Thank you, Charlotte and Michael, and to the City of Anderson for the opportunity to speak at this workshop. Obviously, since 2020, a lot of things changed, and one of those major changes was a lot of funding relief for COVID-related situations. The U.S. Treasury Department has dispensed several $1 million that has come into Anderson County, and Anderson Interfaith Ministries is actually administering those funds for rental assistance. And so I'm quickly going to talk about eligibility guidelines and then how to apply. This particular pot of funding is number one for Anderson County residents. Number two, it is strictly for renters. So unfortunately at this time, this is not a program for homeowners. So you have to be a resident of Anderson, you have to rent. Third, you have to be below the 80% AMI, or the area median income, and that is all based off of household size. You can find all of this information on our website, and that website is www.covidrelief.aimcharitysc.org. And you'll find a good little table there of different number of persons in the household and what that equates to yearly salary AMI. The final thing, eligibility-wise, is this does have to be tied to a COVID-related incident. So it doesn't mean that you have to directly have had COVID, but it does mean that you've been affected, whether directly or indirectly, by COVID. A good example of an indirect situation would be when the school systems closed down. All of our children are not at school anymore. They're in our homes. And so many of our clients so far have seen reduced hours at their job because they've had to take care of their children. They've had to hire babysitters, which led to a significant increase in their expenditures. But it does have to be somehow involved, whether directly or indirectly, COVID related. And that has somehow affected whether income level, reduction in income, or a significant increase in expenditures. So those are kind of the criteria there. On our website, we do have a lot of frequently asked questions, several different scenarios, and I'm sure a lot of people are wondering, well, would I qualify for something like this? We've tried to lay out several different scenarios that we have seen in the majority of the hundreds of applications that have come in so far that'll help you answer those questions. Again, that website is www.covidrelief.aimcharitysc.org. And I mentioned the website name so much because that's exactly how we apply. All of the application process is online, and it can be found at our website. There's a quick pre-qualification page that basically is there to help you save time. making sure you are a resident of Anderson, you do rent, and you are below the local AMI levels there. After that, an email will be sent directly to your email address that you have put in for the pre-application that'll have the actual application attached. If you need any type of assistance, because this is something that is online, technology can be a barrier sometimes, please call our COVID hotline, and that number is 1-833-977-7368, and we can schedule a time that we can walk you through this on our campus and get you signed up for COVID relief. Again, that number is 1-833-977-7368. Charlotte, thank you so much for your time.
Thanks so much, Jordan. That was really wonderful information to have. I was not familiar with all that, so that was really helpful to have that information. So, in the meantime, I've talked about how many times that CDC eviction moratorium has been extended. It's being challenged nationwide in different jurisdictions, as a lot of landlords are making the argument that the CDC eviction moratorium is it's not legal and it's unconstitutional. So, most recently, a federal judge in Washington, D.C. vacated this nationwide eviction moratorium. So, the other decisions from judges had just been local. This federal judge said that it was unlawful, nationwide. However, so we thought that was going to be the end, an early end to the CDC eviction moratorium. That's not the case. That decision is being appealed right now, and the court decided that that decision is going to be stayed. That means it's not going to take any effect until the appeal process runs out. So I think we should be able to get through the end of June 30th with this eviction moratorium still in place. So this is another thing. So this is just another slide that I did just to make sure that it's possible that it can be terminated early. So it's just important to keep your eye on the news to make sure if anything changes. So what happens after June 30th, 2021? So if that, if appeals are still pending and it's not considered unlawful before the end of June 30th, 2021, and the CDC does not extend it, what happens to all the people who, starting from September 4th and through November and January and March of this year, who have completed this CDC declaration? So there is no more protection as of right now after June 30th. So those evictions are going to go forward. I'm not quite sure if everybody had already provided a notification to the court. That should be sufficient for the court then to take action. I don't know if court by court, if they're going to notify then the tenants, if they're going to set them for hearing, but it's important to know that as of right now, after June 30th, there's no more eviction protection under the CDC moratorium. So next we're going to talk about landlord-tenant law here in South Carolina, but I'm just going to talk about the three big topics, and this is what we primarily see at South Carolina Legal Services, and it's going to be evictions, repairs, and security deposit. Those are going to be primarily the sort of cases that we see on a day-to-day basis. So we're going to talk about evictions. So eviction is a two-step process. So first, the landlord has to terminate the lease, and if that lease is terminated and the tenant continues to reside in the unit, then the landlord files the eviction case. And so that's why it's important to understand that the eviction case is just seeking possession of the property only. It's not for any other purpose. You'd have to file a different case for anything else. If you want to recover damages, if you want to recover unpaid rent, sometimes it can be added as part of the eviction, but the primary purpose of the eviction is just to seek possession of that property. So if the landlord files the eviction against you and then you vacate, well, there's just really no reason to go forward. So you can always call, but it's always important to call the court and let them know that you have vacated. So if the landlord files the eviction and then the court agrees with the landlord that the tenant should be evicted, then the landlord has to apply for an additional document called a writ of ejectment. And that is the only way that that tenant can actually be removed from the unit. And so the landlord cannot do that on his or her own. Only the court can order it, and only then will a law enforcement officer actually do the physical removing and setting out of any personal items or furnishings. So there's three reasons that a lease would be terminated. First one and main one is going to be for non-payment of rent. So the main requirement is that the rent is due and the tenant has simply not paid it. And that's unfortunately, except for these COVID exceptions, pre-COVID, whether if the tenant lost his or her job, or if the tenant was in an accident and that's the reason they can't pay rent, well, they can maybe try to apply for some rental assistance, outside of COVID, but it's irrelevant under the law as far as the reason for the non-payment of rent. The landlord is entitled to receive their rent. And so that rent is going to be late on the 6th. So that's, for people whose rent is due on the 1st of the month. So you have until the 5th of the month to pay that rent. And if you don't pay it by the 6th, you are late and the landlord can institute an eviction action against the tenant. However, the landlord does have to give written notice about this. And so most people who have a written lease agreement, you're going to see kind of conspicuous language in there that says if you do not pay rent by the 5th, we can institute eviction proceedings against you. That means because under the law, you only have to give the tenant notice one time. If you don't have, so it's like every time, if the tenant is late on rent every single month, the landlord doesn't have to repeat giving the tenant notices that they're late on rent. If it's included in the lease, that's the only time the landlord has to provide it. If you don't have a written lease, let's say you're in a month-to-month tenancy, the landlord has to give you written notice once. And so if you didn't pay rent in April, you were late, and the landlord gave you notice, but then you went ahead and paid your rent, paid your late fee, and then you were late again in May, the landlord wouldn't have to give you notice over and over again. For the period of your tenancy, they only have to give you that notice once. The second reason for a termination is a breach of lease. So let's say, the tenant has certain obligations under the lease, as does the landlord. So I'll give you an example. Let's say the landlord says in the lease explicitly that no pets are allowed, and the tenant adopts a dog. So the first thing that the landlord has to do is give written notice to the tenant saying, hey, you are in violation of the lease. You have 14 days to remedy this violation. So only if the tenant then gets rid of the dog, then everything's fine. The issue has been corrected. But if the tenant does not, then the landlord can move forward and move forward with an eviction. The last reason for termination would be the end of lease term. So let's say you have a 1-year lease and your lease says you have to give 60 days notice prior to the end of the lease term in order to renew, and neither party does. Well, the lease has ended. Or the landlord simply does not want to renew your lease. Just as, there's no way to obligate a landlord to continue, except for in certain public and subsidized housing. But in private residential leases, the landlord's not obligated to continue to renting to the tenant, just like the tenant is not obligated to continue renting from the landlord. So if the end of lease term, if the term of the lease has ended, there's nothing else to be due, the tenant would have to vacate. If you are on a month-to-month, that means you do not have a written agreement, the landlord would have to give you 30 days written notice at a minimum. And if the tenant does not vacate after that period, then the landlord can proceed with an eviction. So the eviction, we have the rule to vacate. So we've talked about, the lease has been terminated, and if at that point the tenant has not vacated the rental unit, then the landlord can move forward with the eviction. And that document is called a rule to vacate. That's what the landlord files with the court. And so after the landlord files the rule to vacate with the court, the tenant is going to be served with notice. And until the tenant is served with notice, nothing happens. But as soon as that tenant is served with notice, then the tenant has 10 days to do something before that period expires. So if the tenant gets that document on May 18th, they have until May 28th to contact the court. If it comes May 29th and it's 10 calendar days, obviously if it falls on a weekend, it's just the next business day, but it's 10 calendar days. If they don't answer, then the landlord's going to apply for a writ of ejectment. That's the document that actually forces the tenant out of the property. But, so it's really important for the tenant just not to ignore this notice. They've really got to call the court and to, if they're going to challenge it. If they say, well, no, I didn't violate the lease, or I did violate the lease, but I corrected it, I shouldn't be evicted, it's just your opportunity to have a hearing before the court and explain what's going on. So this is also something that is just really important. It seems like there's a lot of information about this, misinformation about this area. So after the rule to vacate has been filed, rent continues to accrue as long as the tenant continues to live on the property. So we get tenants who think that they file, the landlord files an eviction against the tenant, and then they pay the back rent that was owed, and they think that that should automatically terminate the eviction. It does not. And so if, let's say, you owed rent for January, February, and March, and then the landlord files an eviction against you in April, that rent is still owed. And let's say you pay January, February, March, and April, that rent continues to accrue. So a lot of tenants think, well, all I have to do is get caught up and this eviction goes away. That's not the case. It's only by agreement. It's only if the landlord decides to then withdraw the eviction. And so simply because the landlord accepts that rent after the eviction has been started, it does not waive that eviction. Like I said, it's only the landlord at that point can decide whether or not to withdraw the eviction. So this is what the rule to vacate looks like, and that's what I have highlighted there, is just telling you you've been served, and that's why it's very important. In the black and bold, it says you have 10 days to contact the court. Otherwise, they're going to issue that writ of ejectment, and that you can be set out. So this is the writ of ejectment. This is the actual document that authorizes law enforcement to come physically remove the tenant and any personal belongings. So usually you get 48 hours notice, and they're very specific about the time that they're going to come and set you out. So it's very important to not let it get to this point. That's why it's always so important to call the court right away or within that 10-day period after you've been served with the eviction, so it doesn't get to this point. And this is what the writ of ejectment looks like, and this is what you would be served with, and it would tell you specifically the date and time you would need to vacate by. So another thing I wanted to mention is an unlawful ouster. And let's say the tenant just didn't pay rent. Obviously, the landlord has grounds to evict that tenant. However, the landlord cannot just simply go ahead and change the locks or enter the premises and remove and set all of the tenant's furnishings and personal items out on the street. Only a judge can order that. And so if a landlord does that, it's illegal. It's considered an unlawful ouster. Only a judge can order the eviction. Only a judge can order that writ of ejectment, and then only law enforcement can enter and do that. So even if the landlord has multiple reasons to evict somebody, they have to go through the court first. They cannot do it on their own. So I had a client who had not paid rent, and the landlord simply came in and changed the locks. And so my client had not paid rent for 2 months. And so the landlord did have grounds, and we weren't challenging that I did not challenge that they had grounds to file the eviction, but they needed to go through the court. And so if the landlord does that, the tenant does have remedies available to them as a penalty for the landlord having taken the law into their own hands. So repairs, this is the subsection 2 that we're going to talk about. We see this a lot here. So maintaining the property, this is going to be a shared responsibility with the landlord and the tenant. So make sure that the tenant, the landlord obviously has to keep the property in what's called a fit and habitable condition, and you have to comply with building and housing codes. And so they also have to provide essential services. Heat, running water, hot water, those sorts of things. They just have to make sure that those essential services are available. Doesn't mean that the landlord has to pay for it, but it just has to be available when a tenant is renting the premises. So then the tenant, in turn, has to make sure that they keep things clean, they keep it safe, they make sure that their guests are under control and they're not disturbing other tenants. So one of the things is determining who's responsible for paying what when it comes to a repair. So I had a situation where the plumbing was backed up on a rental property. Normally, the landlord would be responsible for making that plumbing repair because that's the responsibility to maintain the plumbing. However, as it turned out, this household were all smokers, and they were flushing down the toilet all their cigarette butts, and that's what caused the plumbing to back up. Well, that burden then shifted onto the tenant, and they would be responsible then for making that repair. So if any time, like I said, for normal wear and tear, the landlord's going to be responsible for it, but if it's due to misuse, abuse, or negligence on the part of the tenant, then the tenant's going to be responsible for paying that. So we're going to have a little video on repairs and determine, we're going to see, that's just going to tell you how you can go ahead and pursue repairs. So I hope
Video 2. Housing repairs. You have a right to a livable home. When you rent a home in South Carolina, your landlord has an obligation to keep that home safe and healthy. This is sometimes called the warranty of habitability. This means that there can be no threats to health and safety or other serious problems with the home. There must be access to essential services like water and heating and important appliances. Examples of unsafe or unhealthy conditions include no heat or hot water, leaky plumbing, mold, pests, missing door locks, and electrical problems. If your house is unsafe or unhealthy because of a condition like this, your landlord has to fix it. It's the law. First of all, as long as you are living in the home, it's best to keep paying rent. If you withhold rent, your landlord may file for eviction. You will then have to raise the issues of repairs while defending an eviction case. Step 1. Notify the landlord. Send a polite and clearly written letter to your landlord asking for repairs. Include a list of all of the repairs needed, when the damage occurred, and a reasonable deadline to make the repairs. Usually, it's best to give your landlord at least 14 days. Your letter also needs to say what you're going to do if repairs aren't made. So you'll need to make this decision now. You have two options. If you want to leave, you have this option if the problems with your home materially affect health and safety. They can't be minor problems. You also should have given your landlord written notice of the problems and at least 14 days to fix them. It's best to send any letter certified mail or send it with your rent check so you have proof the landlord received it. Be sure to keep a copy. You can create a letter using a tool on SCLS's website. If you want to stay and try to make your landlord fix your home, you can file a lawsuit asking the court to order your landlord to make repairs and possibly to award you damages. You can do this with or without a lawyer. You can create papers to file in court using a tool on SCLS's website. Step 2. Evidence. You need to make a record of the problems with your home. The best way to do this is to take lots of pictures. Make sure that you document all of the problems and that there is plenty of light to see the problems clearly. Record the date that you took the photos. Step 3. If the landlord does nothing. If you decide to leave, you can simply move out and stop paying rent. You don't need to file anything in court, but it is an option. There's more info on that on SCLS's website. Once you move, you should write to the landlord to ask for your security deposit and prepaid rent back. A sample letter is on SCLS's website. If you decide to stay, you can file a complaint with the court. It will need to be served on your landlord. The court can have this done for you for a small fee, or you can have it done yourself. Once your landlord is served, they have 30 days to respond, called an answer. Once the court has received the answer, they will schedule a trial. If the condition of the house is very bad, for example, you don't have heat, electricity, or running water, you can ask the court for an emergency hearing to decide whether your rent should be reduced or if your landlord should be ordered to make repairs immediately. When you come to court, make sure to bring all the evidence you collected. Print out any pictures you took. If you have any witnesses, make sure they come too. You won't be able to use written statements from witnesses. SCLS has created an online resource to help you take action to get repairs from your landlord. Here you can create the court forms you need, letters to your landlord requesting repairs, contact information for city and county agencies, and more.
So I'm going to have some of these forms available, and these are just pretty standard forms that you can just fill in with a landlord's name, your name, and explain, just fill in and says, what the repair is needed. So I'm going to have some of these forms here, and I believe it might be possible that Miss Mary or Miss Erica will be able to add that to the website. But of course, all those forms are available on our website at sclegal.org. So in that video, Clark, that's our cartoon's name, mentioned security deposits. And so there are times when a landlord can keep security deposits, and that's if the tenant terminated a lease early, there's pretty, abnormal cleaning costs that are above reasonable wear and tear, the tenant didn't pay rent, there's unpaid utilities, or there's just simply damage to the property. But one of the things that we would recommend before you move in, take pictures of what the apartment looks like or your house, rental house looks like before you move in, and then make sure you also take pictures before you move out. So the landlord has to either return that deposit or it has to return what's left after taking deductions. But they have to include, if they're going to deduct from your deposit, they have to include an itemized list of what those deductions are. And they have 30 days to do that. But it's very important that that clock doesn't start ticking until the tenant actually asks for that security deposit back. And so we also have a sample letter that says, landlord, I've moved out. You have 30 days to return my security deposit. So if the landlord's going to be deducting anything, it really has to be careful about doing that. And there is a penalty for wrongfully withholding a security deposit. And so if that's the case, then it's possible that the tenant could, as a penalty, could get 3 times the amount of the wrongfully withheld security deposit plus the attorney's fees. Okay, so again, that's our website at sclegal.org. Our application telephone number is 888-346-5592. So thank you so much, everybody, today in the city of Anderson. And if you have any questions, like I said, you can always apply to see if you qualify for our services. But this information and these forms should be available, definitely available on our website, and should be available on this website shortly after this presentation is posted. So thanks so much, everybody.